Well, I will begin, as we philosophers are so often accused of both beginning and ending, with a few definitions and distinctions. First, the word euthanasia. The English here derives from a classical Greek compound meaning, literally, good dying. Good dying is in this context primarily quick and painless dying. And in modern English usage, euthanasia is good dying only in certain particular circumstances. One unfortunate and unintended consequence of the progress of medical science and medical technology is that these particular circumstances have, during our lifetimes, become much more common, and will, it appears, most likely continue to become steadily commoner throughout the foreseeable future. Are people having trouble with these microphones? It's okay, is it? What I hear is two microphones in evil adjustment one to another. Okay, if it's all right for you, that's the main thing. These particular circumstances are those of an adult person afflicted with some condition, typically, but not necessarily, a terminal illness, some condition which they themselves find intolerable and which cannot be satisfactorily relieved or cured. So that's euthanasia. Second, there's the always vastly important distinction between voluntary and compulsory. All euthanasia pressure groups in the several countries in which such groups are now operating insist with every possible emphasis upon that qualification, voluntary. Our British organisation, founded in 1936, and I may add, with I hope pardonable national pride, the first in the world, always used to call itself the Voluntary Euthanasia Society, until at our last annual general meeting we changed the name to EXIT, the Society for the Right to Die. The three groups in Australia, in Victoria, New South Wales and Western Australia, all include the expression voluntary euthanasia in their titles. Since what we are all after is the establishment of a new and so far legally unrecognized individual right to choose, the very last thing which we want is either to enforce euthanasia upon unwilling patients or to compel doctors and nurses to administer or to assist in the administration of euthanasia to other people against their, i.e. the doctors and nurses, own will and conscience. Some of our most vociferous opponents are, I suspect, so committed to the principles of Imperial Germany, where notoriously everything not forbidden used to be compulsory, that they find it hard to accept, even especially in this matter of life and death, that we do actually and truly want everyone to have their own legally protected individual right to choose for themselves. To quote the title of a play recently staged in London, whose life is it anyway? A still commoner objection on the same lines may start by allowing that the legalization of voluntary euthanasia would in itself be good, but that it would be the first step on a slippery slope down towards something far worse, compulsory euthanasia. It's become customary here to make some reference to one of the crimes of German National Socialism. Well, terrible crimes indeed they were, though fewer perhaps than the earlier and still continuing crimes of Lenin's International Socialism. The argument, however, will not do at all. The National Socialist program of forcibly and murderously emptying asylums for mental and other defectives was neither historically nor logically a continuation and extension of some prior policy for individual choice. An example, has the decriminalization in Britain of the sin of Sodom been but the first step on a slippery slope to universal and compulsory homosexual sex. Well, third point, we have to notice the distinction often made between active and passive euthanasia. This distinction is best explained by quoting once again some familiar lines. Thou shalt not kill, but needs not strive officiously to keep alive. Active euthanasia involves the killing of patients, whether by themselves alone or with the assistance of other people. Passive euthanasia is a matter of letting them die, whether by suspending or by not starting some form of life-maintaining treatment. The desired distinction between killing and letting die is in some cases rather hard to make. What, after all, are we to say about switching off systems of life support apparatus? This would, in other contexts, be admitted as a paradigm case of active doing, and yet the patients will die naturally if they are not constantly provided with such highly artificial support. I myself doubt whether we can maintain any such distinction as being a morally crucial distinction. But my own main objection to describing the active and the passive as both cases of euthanasia is that this begs that question of whether we can make this a morally crucial distinction against those opponents, most obviously Roman Catholic opponents, who would insist that precisely that distinction is crucial. Many of my colleagues in the euthanasia movement leapt upon the recent statement of the Sacred Congregation for the Doctrine of the Faith, interpreting this statement as saying that the Roman Church is now prepared to allow passive euthanasia, and then they asked rhetorically, so why not active? Well, certainly these colleagues were absolutely right to welcome this genuinely compassionate statement. If only, I cry, all our doctors, especially those working in dangerously richly well-equipped hospitals, if only they would indeed take this statement to heart, acting or not acting accordingly, then far fewer patients would suffer vexatious, unwanted treatments and surgery applied when these can only protract the miserable business of dying. But that sacred congregation, consisting as it does of well-instructed Roman Catholics, would defend the active-passive distinction as being, what I don't believe it is, morally crucial. Given their argued, though I believe mistaken assumption, they maintain that what others might call passive euthanasia is, when licit, not euthanasia at all. So much for the third point, third distinction. Fourth, and under my first heading, finally, there's the distinction between suicide and murder. Murder is the wrongful killing of someone else. Suicide is the killing of oneself, something which is considered by many to be itself always wrong. Since I am not of their number, I prefer to speak and to write suiciding rather than dyslogistically committing suicide. I also recommend this, in two senses, non-committal practice to other people. But even if we believe that suicide is indeed always morally wrong, this is by no means the same as showing either that suicide and assisting someone else's suicide should be criminal offences, or showing that no one has any moral right to decide for themselves whether or not to commit this supposed moral offence. The principles of imperial Germany cannot be taken for granted, but must at least be argued for. If you think something is immoral, you've still got to offer some argument for making that immorality a criminal offence. I put it to you now that it's obvious that in a context of moral debate, voluntary euthanasia is one special case of suicide. This, when the agent is the patient, it is scarcely possible to deny. But then, if once that's admitted, how is it possible to deny the corollary? Namely, that when the agent is somebody else, that somebody else is acting as the instrument of the patient principle. So the question immediately arises whether suicide is always morally wrong, and in particular, whether it is wrong in a typical euthanasia situation. Well, the main traditional secular argument for the immorality of all suicide can here be dismissed as an almost indecent irrelevance. For the terminal patient wanting euthanasia neither is nor is going to be able to perform further useful services. Services either to the state, or I would think more to the point, to flesh and blood other individual people. Indeed, one of the chief reasons which such patients in fact have for wanting to stop it all now precisely is that they are, and so long as they live must remain, nothing but a burden both to themselves and everyone else. Two other favourite arguments, a bit more worthy than that rat bag argument, or in this context it is. It makes sense in some other context. So, two other favourite arguments are essentially religious, notwithstanding that often these arguments are employed by persons by no means conventionally devout. The first may be summed up in the claim that life is a gift, which, even when it is unwelcome to the recipient, only God or nature is permitted to withdraw. The weakness of this argument is that, until and unless some supplementary revelation is provided, the embargo has to be extended to cover far too much. For if it is forbidden in all matters of life and death to interfere with nature, then any and every form of artificial death control must be forbidden. Inoculations against killing diseases and life-saving surgery become interferences just as illicit as active euthanasia. It's taking the choice out of God's hand by giving him a shot of penicillin. Now, to meet this objection, appeal has to be made to a second favourite argument. Implicitly or explicitly, this argument maintains that the necessary revelation has indeed been provided, and that the absolute ban on any taking of innocent and human life is grounded upon this revelation. About such revelation claims in general, I will say nothing here. Some people in the present audience will know that I have elsewhere said plenty. But suppose that the claim is in particular to a biblical revelation. Then I don't see how this claim can be made out. There are precious few mentions of suicide in the Bible. You should read it sometime. And for fairly obvious reasons, none of these could be called cases of active euthanasia. Those suicides which are mentioned are never, I think, condemned as such. So the burden of proof here falls onto the sixth commandment. It simply cannot sustain that burden. Certainly, in the King James Authorized Version, that commandment is rendered, "Thou shalt not kill." But if we go so far in scholarly good faith as ourselves actually to read Exodus 20 and to read it in context, then we find that both in the previous and in the subsequent chapters, much is said about kinds of killing, and killings of human beings at that, killings which are not merely permitted but commanded. This, presumably, is why the Revised Version, the Book of Common Prayer, and other more recent Bible translations also prefer to talk of murder rather than without prefix or suffix killing. That's making it read, "Thou shalt do no murder," no wrongful killing. Well, perhaps I treat myself to a sort of footnote to that brief essay in Biblical Exegesis. And as this footnote, notice that St. Augustine initiated a movement to assimilate suicide to murder. And self-murder, suicide, has to be put down as, for reasons of Christian eschatology, a peculiarly damnable offence. Well, we ought to give the shortest shrift to at least the non-theological aspect of this manoeuvre. For the nub of the distinction precisely is that murderers kill other people against those other people's will, whereas suicides kill themselves, and do so when and because they themselves want to die. The saint might as well have asked us to join him in condemning intramarital sex on the grounds that it's nothing but own spouse adultery. When our Voluntary Euthanasia Society was first formed, and even 30 years ago when I signed up as a life member, the main emphasis was perhaps upon extremes of physical agony, while the main concern was correspondingly humanitarian. I believe that, mainly in reaction to the consequences of medical developments, things have changed in those years. The police have got much younger, for one thing, but that's not the thing I want to mention. There seems now to be at least as much emphasis upon other forms of distress and upon indignities, while the moving concern is also at least as much libertarian as humanitarian. Certainly, whether that's right or wrong, my own arguments now are primarily arguments for the legal recognition of the patient's right to choose. And I believe that I would continue to campaign for this almost, if not quite as strongly, even were I persuaded that, given the choice, most people would in fact choose to go on existing on terms under which I myself would choose to die. So, along with most of my colleagues in the euthanasia movement, I see the whole struggle as primarily directed to the removal of the present legal obstacles to the exercise of a very fundamental individual human right. It helps, I think, to divide those legal obstacles into two kinds, with the line of separation, a rather rough line of separation, that suggested by the distinction which I made at the beginning, reluctantly, between passive and active euthanasia. On the one side, we have all the law which permits or requires doctors and nurses and such persons to impose treatments which their patients may not wish to suffer. Now, it's sometimes said, even by people paid to know better, that in fact there's no such law, and that patients in our two countries are already sufficiently protected by a common law right to bodily integrity. I am, of course, no lawyer, but I can and must say that if there is indeed such a legal right, then in practice, in Britain, it is secured just about as effectively as are, in the USSR, the rights guaranteed to the Soviet citizen under the Stalin Constitution. I could, but at this stage will not, tales unfold under both this and other headings. Tales which would, in the full telling, cause many good lunches to be vomited to waste, which is one reason why I'm not going to tell them. On the other side, the active side of the divide, we have, in the first instance, the law of suicide. In Britain, suicide itself ceased to be a crime in the early 60s. And I'm told that many, though not all, Australian jurisdictions have since taken the same course. My informants, having a thing against Queensland, have been eager to point out that Queensland hasn't. And no doubt they've wanted to add that in Queensland, homosexual offences between men and women are criminal. But still, I don't vouch for this, but this is the sort of thing that people tell you about Queensland. But assist suicide, in Britain and certain states in Australia, suicide itself is no longer legally a crime, but to assist suicide remains in both our countries everywhere a serious crime. At this point, everyone else here is entitled to one thrill of national pride, for it was an initiative of one of the Australian societies which persuaded our own that to try for an amendment of laws against assisting suicide is an immediately more promising tactic than to try once again for a Euthanasia Act. The sort of thing that Tom Paramore had in mind here, he's the Sydney-sider who thought this up, the sort of thing would be an amendment to decriminalize such assistance, save when that assistance was given with evil intent, and leave it to the courts to sort out when the intents were evil. Well now, at last it's time, you may think long over time, for me to say something short and direct about my subject as advertised, the right to death. Here, happily, very short can also be sufficient. I put it to you all that the right to death is implicit in the right to life, and that this right, surely, is accepted as basic by everyone who can find any room at all for a doctrine of universal human rights. Of course, any such doctrine requires a general rationale, such as, I may say, is conspicuously wanting from the European and United Nations declarations. I've tried to do something about that myself elsewhere. But it's enough now, I think, to bring out what always was implicit in the splendid words of the American Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, and endowed with certain natural and unalienable rights, among these being the rights to life, liberty, and the pursuit of happiness. Now, I wouldn't, of course, want to maintain that all or even any of the signers saw all the implications of this most magnificent of political manifestos. Certainly, for example, many of the Southerners seem not to have realized that all men means all men, black and white together. Again, only some few signers would have been quite wholehearted in their acceptance that all men must here, so to speak, embrace all women. But because these implications, everyone would agree, are there, even though they weren't seen by the signers, I'm going to remain entirely unmoved by any protests that few or none of the founding fathers would have construed the right to life as it clearly does have to be construed. That is, as a right not to be deprived of life against your will by other people, but instead to continue or to stop living as you yourself see fit. It is, I contend, manifestly absurd to persist in the alternative interpretation, namely, that it is a right, yes, not to be killed by others against your own wishes, but one combined with a compulsion to stay alive in any condition and regardless of your own wishes, just so long as other people, employing any means they may see fit to use, can contrive to force you to keep ticking over. About this I want to say, what a right and what a threat.
Well, following practice, the topic is open to discussion. There are microphones around the hall. Would those who want to ask a question or make a brief comment move to a microphone and please announce their name so that they can be identified.
Professor Flew pointed out that he was concerned with changing the laws on this matter of voluntary euthanasia. And that is what my question is principally about. What he is recommending is not a right to death, but a right to kill on the part of those people licensed to administer assistance to suicide. Now, as one of the conventionally devout, I'm not a Roman Catholic, I'm a Calvinist, this is not a law which can possibly be accepted in any society in which we live, and it is a law which, if it were enacted, in my opinion, ought to be resisted, if necessary, by force. Not by the taking of life, but certainly by force. It should be withheld. Who is to say that a plea, in the worst possible case, a plea for death, entitles oneself to say, very well, I will kill that person? I think everything that Professor Flew had to say about the distinction between passive and active euthanasia goes along those kinds of lines. It is not the case, by the way, that everybody who believes in universal human rights does not think that suicide is morally wrong. Alan Donegan, a couple of years ago, published a philosophical work which was very convincing on this subject and was based on one's duty to respect any rational human life, even one's own. The second point that I want to make is that any kind of legislation of this sort would not lead necessarily to Nazi Germany, but it certainly would lead to a great increase in the already evident instances of younger people who wish to get rid of grandma. They do. It's undoubtedly the case. Anybody who thinks it's not the case are too innocent to be sort of out of their mother's protection. There are plenty of people who will induce grandma to take an overdose, pointing out that she's got nothing to live for, she's in pain, and really you'd put down a dog if you're in the position of grandma. Now that's one thing, and that is a very important thing. I want to make the point, and I want to make it to Professor Flew, that the overestimation of the virtue of all human beings without exception, there are many who are fine, but the overestimation of the virtue of all human beings without exception, the unwillingness to consider the malice which some human beings are capable of, should make him pause before he supports the kind of legislation that he wants to have introduced.
Well, on the last point first, you must be the first person who's ever accused me of over-optimism about anything, and particularly over-optimism about human depravity. Now, about these other things, I find it very difficult to see how one can come to grips with this, because what you've been saying, I think, amounts to an expression of your own extreme horror at the idea of anyone killing anyone in any circumstances at all. That's right, is it? Yeah. Well, then clearly this is not a biblical position, because for the reasons I gave here. Yeah, I don't know really what there is to be said about that. If that is your fundamental position, that no one is to kill anyone at all in any circumstances for any reason, yeah, well, that is your position. I think we want to have something more as to why your own scruples about doing this have to be imposed on other people, why other people have to be prevented from getting something that they want because you disapprove of it being done when they want it. You know, I think it comes down to a bitter thing. I want to say, what right have you to try and stop someone who desperately wants to die being helped to die because you're offended about this? Why do you want to impose your principles on other people against their will? I think I'm going over to the offensive about this.
Anne Russo. Professor Flew, don't we have a problem in voluntary active or voluntary passive euthanasia in maybe the patient having changed his mind from having, maybe before when he was well, he did want it and he might have changed his mind even if he wrote a living will or anything like that? Is this a problem?
Well, it's not a problem in the sense that it's one to which there isn't an easy answer. No one is proposing that any statement that someone made in advance should be acted on if the person had changed their minds in the meantime. If you want to say, as some people do, but you know, they might have become unconscious and they would have said something different if we'd been able to wake them up. Well, I think this would be, perhaps you're not wanting to make that, but it would be a very arbitrary thing to do, because after all, why apply this argument only to when they change their minds in this direction? Why aren't we to apply this argument about what they might have said if they were ever going to be conscious again to the case of someone who say, I want to be kept alive in all circumstances, regardless of anything. I want to go on, even in any sense. Well, I say, perhaps they would, if we could wake them up now in their state of deep unconsciousness, want to change their minds. Well, I don't want to argue from this hypothetical change of mind in a state of deep unconsciousness in that case, and I don't see why anyone should in either case. So I think this objection, the basic point, can be fully met by insisting always that people should always be entitled to revoke. These are sometimes called living wills, as of course is the case with your last will and testament about your property. You're entitled legally to revoke this on your deathbed, and there are a lot of old-fashioned novels which are about people doing just this, aren't there? So I think that can be met.
Lyle Dunn. Professor Flew, you've made this distinction between voluntary and compulsory euthanasia that you obviously see as crucial to your entire case. And I see that from the point of view of hoping to convince legislators anywhere of the value of your case, it is crucial. And you seem to be putting the position that this is the barrier that you'll never cross. Incidentally, when I heard the term compulsory euthanasia, I wondered what this could possibly mean when you defined euthanasia as good death. But that was cleared up when you explained that good meant quick and painless, not good in any deeper moral sense. So I suppose one could have good, compulsory good death in that case. But I would submit that this distinction isn't quite as clear-cut as you would wish it to be, because in all currently existing legal situations where there is provision for consent, I believe, where an individual is deemed by a court of law or some other competent authority to be incapable of making such consent, there's usually provision for someone else to make that consent on his behalf. So I can see that your society or the supporters of your position, much as they've changed their views from thinking that euthanasia is something which ought only to be required in cases of extreme physical agony, to something which could be applicable in cases of mild physical agony or personal indignity, could similarly change their minds and say, well, okay, we've now got the situation where euthanasia is applicable to all those who can personally consent. Why should it not be applicable to those who are incapable of making the decision regarding consent themselves, and in every other case have provision for making such decisions passed on to somebody else, be it parent or guardian or the state? Why can't we then decide that the state or institution which is capable of making decisions regarding mental defectives, for instance, could be equally empowered to make this decision, so that we then can euthanize mentally retarded children without having to worry about the fact that they're incapable of giving consent? I think that this would provide the barrier to cross this great gulf that you assure us will never be crossed. And I see that in doing so, we could be much closer to what you described as the principles of Imperial Germany, by which I presume you meant Nazi Germany.
No, I certainly didn't mean by Nazi Germany Imperial Germany. I meant Imperial Germany, which ended in 1918. No, so not that one at all. Well, I don't know that I can say anything more usefully about this than is it just does not seem to me sensible to maintain that making something compulsory is at the bottom of a slippery slope that begins with extending people's right to choose in this area. I mean, is it the case that there's now a great campaign to make homosexual sex compulsory now? Shut up the heteros and stop it, confiscate copies of Playboy and so forth, and replace them all by a compulsory issue of gay. Not true. I mean, here we have an example of something where a legal ban on people's choice as to what they do in decent privacy, or in indecent privacy in this case, is removed. It doesn't lead as the logical next step to making whatever it is compulsory. I cannot see that an extension of human rights in this area is the logical first step towards making it compulsory. I'm inclined to be mischievous, too, about the appeal to legislators. I think there are many legislators, particularly socialist legislators, who would be attracted only by something that involved more compulsion, rather than an extension of liberties. But still.
My name is Jenny Stokes. This is a rather prosaic request for information rather than a point of principle. What's the present situation with Exit's booklet on how to do it?
Well, I'm not completely up to date on this because I left Britain on July 7th. But let me say briefly, the situation when I left was that we got the text written mainly by our Doctor Committee members, and we were consulting Queen's Counsel just as we thought to check that we were legally in the clear. I mean, the advice of our lawyer members, including one who even writes the textbooks of criminal law, was that there would be absolutely no legal objection to publication at all. Apparently, while I was away, these Queen's Counsel came up with the advice that we might be liable to a prosecution for the crime of assisting suicide. The executive committee of the society, in the face of this, realizing that this sort of prosecution, if a conviction followed, would be professional disaster to all of them who were practicing lawyers or doctors for a start, decided they could not go ahead with printing it. Now, the next stage I'm not clear about. What the press reports suggested that there was some sort of rebellion of our Scottish membership where, as you may know, the legal system is different and where the British Suicide Act doesn't apply. I don't believe it was like that at all. I believe it that our very energetic General Secretary was on the blower to Scottish members saying, what are you going to do about it? And persuading them to go ahead. And apparently they are in process of printing this, but not distributing it to any but their fellow Scots. He ought to some of us here, wouldn't he? What happened next is that I, for one, and I'm sure the Secretary, are absolutely determined we're going to get this out one way or another. I mean, we'll get it printed in the United States and under the protection of various constitutional amendments and the Bill of Rights and so on. But the position in Britain, as far as I know, is that they're going ahead trying to publish it by Scots and for Scots, but the English part of the society is stuck. I mean, there may very well be a move at the next annual general meeting to elect a new executive consisting of members who can afford to be prosecuted. And we've got enough people over the age of retirement, including some quite distinguished chaps whom the public prosecutor might be rather reluctant to have in court, like Arthur Koestler saying. But, you know, that might well happen.
My name is Father Peter Murnane. Just to clear up a fact or two, Professor, you finished on a note of fear that others would keep you alive, unjustifiably. Medical practice, in the best of my experience, is not in that direction. There are abuses, surely. I was talking last night with a Catholic doctor who is quite involved in keeping alive, where necessary, terminally ill or accident victims for many years, going on the Catholic Church's teaching, quite clearly put in the early 50s. He does not see any need to keep alive with complicated artificial means. For instance, he wouldn't try to cure pneumonia in a nursing home. That's a natural way to die. It ordinarily carries you off. You wouldn't try to give a drip feed or keep a person alive. And that's not new in the euthanasia document you quoted last year or two. You seem to be confusing a threat of people wanting to keep you alive, and that would indeed be an illegal and improper thing, with the right taken upon oneself to end one's own life. To me, it seems a basic confusion. Another matter I'd like to point out is that, arguing from the Old Testament, the book of Deuteronomy, which is 1,000 years or more before Jesus Christ, is not exactly the way to look at Christian morality today. We have to look at the permissive law in that case, to stone adulteresses. Adulterers were more favourably treated. That's way out of date. Jesus treated adulterers or adulteresses very differently, the mercy shown and so on. So don't confuse the Old and New Testaments. There's a very strong evolutionary process through that teaching, which was reaching perfection in the Christian belief. Thanks.
Well, first, I'm sure what you say about the best medical practice is true. It's even tautologically true. I wouldn't call it the best medical practice unless it was working on these lines. Second, I didn't actually say, but of course I am well aware of the fact that this latest statement by the Sacred Congregation is not a new move at all. It's a restatement of something that I had certainly seen stated many years before. Old Testament and New Testament, well, it's not my fault that people appeal to that particular commandment as mistranslated. They do. And suggestions that they ought to look at the New Testament should, I think, be referred to them here. One final thing, though, the deaths of General Franco and the late King of Sweden in his 90s. What did the doctors do? Did they try to make that splendid old man comfortable and, make the funeral preparations and get ready to pay tributes to his 50 years as a splendid chap? No, they operated on him, for goodness sake, just to keep him going for another day or so. Similarly, with that perhaps rather less splendid old man, General Franco, they were operating like fun. Now, another case. We had come before us at the Euthanasia Society, and we're still trying to get the people concerned to bring a prosecution for assault against the hospital and the doctors concerned. Case of a person whose wife had been in an intensive care unit. She was a terminal patient under intensive care. He didn't want this to go on, and emphatically she didn't go on to get it on. She protested against this treatment, being stuck all over with tubes. Did they say, oh, you have a common law right, we'd advise you against, but of course we must pull all the tubes out? Did they? Hell. So they did nothing. So she tore all the tubes out. Did they then say, oh, you have a common law right to the integrity of the person, the best medical practice won't do this? Did they? Hell, they strapped her arms down and put the tubes in again, and kept that going until she died. And her furious husband came to tell us about this, and he wants to get a prosecution for assault. I very much hope he does, because one of two good things will happen. Either the doctors concerned will be convicted of a criminal assault, or they won't be. If they are convicted, this may make medical practice in some other places rather better than this in that hospital. If they're not, it may wake up the public to the fact that these rights to refuse treatment are not being generally respected. Though, of course, they are respected by good doctors, and they would be respected by more if more doctors would read that statement of the Sacred Congregation and take it to heart, as I'm sure you have.
All these references to Scotsmen, I think, gives me a lead in to this question, being a Scot myself. At present, the law forbids persons from assisting at suicide, and I think you made the point that this is the law that you want to remove. Now, at present, the elderly and handicapped know that they can't legally get assistance in a suicide. But if we remove this law, don't you think that society can be regarded as recommending suicide to the elderly, the handicapped, and the sick? And does this not put pressure on the sick and the elderly and the handicapped actually to commit suicide, even although they perhaps don't particularly want to? Their life of a handicapped person towards the end of his life is possibly a burden to them, knowing that they are themselves a burden to others. And this removal of this legal protection would perhaps put an even greater stress on the sick, the elderly, and the handicapped. One point you mentioned was raised, I think, about the children. One of the questioners raised, do you recommend assisting the sick, elderly, handicapped infants towards an early death? There is one major problem, as I see it. You mentioned, I'm very delighted to know that you haven't forgotten your father's teaching about the Bible and the Bible references. The only reference in the four Gospels, I think, I'm not much of a scholar, is to Judas Iscariot. Now, that's not much a recommendation to suicide.
Well, it may not be a recommendation to suicide. I mean, it gives it a bad name, doesn't it? But it's not actually condemned as such in that context, is it? I mean, no one comments on this and says that, and this is the last straw, apart from his other delinquencies, he then kills himself. There's no sort of teaching given there. About your other points. I think there were two ones. One about the possibility of people being over-persuaded. A lot of people say this to me. My own failure to persuade other people of almost anything when I very much want to persuade them, and when it's not for them a matter of life and death, makes me rather less alarmed by this prospect than some people think to be. But most seriously, I think people are very, very, very difficult to persuade in this sort of matter. The second point about removing a legal ban on something. I don't see that removing a legal ban on something is going to be or necessarily taken as a sort of legal encouragement for doing it. Does anyone think that removing the criminal penalties on homosexual sex is properly to be construed as, the Parliament in question saying, hooray, there should be more of it? I mean, it was a thoroughly heterosexual Parliament. There was the usual quota of MPs in the courts about adultery and so on at that time. And no one thought that they were wanting to encourage something that they did, in fact, decide to make no longer criminal. I don't see why this should be taken as being so anyway. I mean, whether this ought to be encouraged is another story. I mean, I'm inclined to think it ought. But still.
The last question.
Okay. Thank you. I'll make it quite short in view of the time. I just had one question to do with the putative wide-spreading nature of this law. How comprehensive would it be? If I could just give you a scenario. Perhaps if I were in a car accident and suffered grievous bodily harm, lost 2 legs and was blinded and suffered grievous physical deformity, and in the depths of depression in the hospital intensive care ward, really honestly felt that I wanted to die and said so to the medical officers, would they be able to gainsay that, or would they have to take me at my word, even given the fact that a pattern is often developed where depression would set in a very seriously wounded or harmed person? How would you draw the distinction? I mean, you've been talking about terminally ill patients, but to me this would also be something which would have to be considered, and it would be very difficult to draw the line between it. What is your response to that? My name is Adam Shoemaker, by the way. Sorry, I should have said it at first.
Yeah, I can see there are problems about this one. Yes, certainly. But presumably they can be met by the distinction between the terminally and the non-terminally ill, can't they? I mean, the non-terminally ill person who wants to dispose of themselves will certainly be able to do it when they've recovered. The terminally ill person is the person who raises a problem because they may want to and not be able to do it for themselves.
And briefly to that, I would have thought, though, that what you're arguing is on the basis of an individual right to determine one's fate, and therefore on that basis it would be logically contradictory, because you're stating that every person should have the right to determine when his or her life will end. And if I were in that position and stated that honestly, and who is going to gainsay that in this position? See, this is the difficulty I see.
I was taking it that you were assuming a case of the accident victim who was making a rather, what we will all agree was a rather temporary protest. It's too awful, I don't want this to go on. Well, I think everyone talking about euthanasia has always wanted the crucial decisions to be made over a stretch of time. After all, this is a life and death matter, and there ought to be at least as much a demand for time for decision, for possibility of second thoughts, as our lawyers traditionally made in that other, as it used to be, whole life matter, marriage, where it used to be impossible to get married without, having a bit of time for thinking and wondering whether it was the right girl, man, as the case may be. Well, I think if you insist that there should be a bit of time involved, I think that probably meets your case, doesn't it?
Thanks very much. Yes, I think it might.
Well, on your behalf, I'd like to thank Professor Flew for his instructive as well as challenging address, and I would finally also like to thank you all for attending this convocation lunch.